afternoon, everyone. My name is Karen Tereposky. I am a senior associate at Sunfield Tumarkin's office in Calgary in the employment law area, and I'm here today to answer questions that anybody who's watching or listening might have about employment law or human rights or anything in that department that relates to your rights as an employee in Alberta. So usually we get quite a few good questions, and it's usually an interesting half hour. So hopefully we get some good ones today. While we're waiting for those questions to go in, some stuff that's been in the news is there's a Scotiabank is laying off quite a few employees right now, even though they've been called back to the office and are complying with that callback. So we get a lot of people asking about, being called back to the office and, if an employer can do that, right? And, the answer is generally that an employer does have the right to, manage your workplace. But if working from home has become a term of your employment contract, or it actually is a written term of your employment contract, then it's not quite as easy for an employer to do that. They have to give you a lot of notice or have you agree to that change. But interestingly enough, with Scotiabank, what's happened is they're getting people to come back, or they've recalled people, they've complied, and then they're laying them off, or they're terminating their employment. So kind of harsh when somebody's complying with a policy that maybe they don't want to, and then they're losing their job anyway. So, but it's not a case where they're alleging cause for dismissal or anything. It would be just cause or without cause termination, where they'd have to be provided with their full severance. So obviously, when you're looking to see how much a full severance would be, you're looking at a bunch of factors, which kind of go to how long is it going to take that person to find a new job. One thing that I've considered when, an employee is terminated from their employment and they've been working remotely is that might factor into the length of their notice period. So when we talk about, how much severance or how much notice are you supposed to get of termination, we think about factors like age, years of service, availability of similar employment. And something that I've argued in quite a few cases when you're talking about availability of similar employment is that if you're working remotely, that's a factor. And if it's similar employment, then does it have to be another remote position? If your replacement employment is going to be remote, then it's possible, and I haven't actually seen any reported cases on this yet, but I think it could go that way, that a court would go, well, you're probably going to have a longer notice period, because to find another remote position that pays you the same is going to be more difficult. So the employer would have to give a bit more notice. So the interesting part of that is that in these cases for Scotiabank, when they're bringing people back into the office, you start thinking, well, are they doing that to get rid of that factor so that their severance wouldn't be as much, because now they're not a remote worker anymore. They're coming back, now they're in the office, and then they're getting terminated. But, if you're in that situation, a good thing to do is obviously be to check your severance entitlement, or, an estimate in our pocket employment lawyer, which is on our website. That'll give you an idea of how much you could expect to receive, or, set up an appointment to talk to one of us. We do have a question here from Priya. I was told I'd be promoted after maternity leave, but when I returned, the position was given to someone else. Can I claim discrimination? So in order to, when you talk about claiming discrimination, basically what you're talking about is making a complaint to the Alberta Human Rights Commission. The way that human rights law worked is you have to have a protected characteristic under the act. So in this case, it would be gender or family status, maternity leave, being on maternity leave. That's how you become protected in this situation under the Human Rights Act. So what's happened here is that, you've been told you're going to be promoted, you've came back, and to say it's because of discrimination, you would have to link the fact that you did not get that promotion you were promised with the fact that you were on maternity leave. So that has to be part of the reason. If the company can establish that, that had nothing to do with it, then it wouldn't be discriminatory necessarily. But what happens when you make a complaint to the Human Rights Commission is, if you raise what they call a prima facie case, or, on its face, it looks like this adverse effect you experienced in your employment. If it looks like that had to do with a protected ground, so gender, or, having to do with your maternity leave, it likely would get accepted. At some point, though, it would be a case of, can you actually establish that the maternity leave or the gender factored into this termination? Or can the employer establish through emails, meeting notes, etc., that they didn't even think about the fact that you're on maternity leave. They just had they had a suitable candidate and they put that person in. So, I think you can claim discrimination. And you could make a complaint to the Alberta Human Rights Commission. Whether or not that would be successful depends on a lot of things, and it depends on whether or not the employer could establish that it really had nothing to do with the fact that you were on maternity leave. So it's a little bit more complicated, I guess. I don't think it's necessarily no, you can't claim discrimination, or yes, you can. But what's happened here is that you've suffered an adverse effect in your employment. And the question is whether or not it was related to your protected ground. So, you can claim discrimination. Where that's going to end up, I couldn't guarantee at this point. Another question from Denise. I signed a non-compete clause years ago, but now it's stopping me from taking a new job. Are these clauses actually enforceable? So if it is actually a non-compete clause, those are difficult to enforce. The test that a court looks at in the case of these clauses is whether it's reasonable to protect the employer's business interests. Non-competition, which means they're saying you cannot work in the industry, is a very high standard to prove that that's necessary to protect business interests. A lot of people, though, refer to what are actually non-solicitation clauses as non-compete clauses. So I'd want to take a look at your clause to see if it actually is a non-compete clause or if it's a non-solicitation clause. A non-solicitation clause is quite a bit easier to enforce. Again, it just has to be reasonable to protect your employer's business interests, or your former employers, I guess. So what a court would look at is, is it reasonable for this employer to say to you, well, you can't, solicit our clients. You can't go out and try to take our clients away. So those ones are easier to enforce. So sometimes they are enforceable. As I said, the non-compete ones are more difficult to enforce. It's not that they're never enforceable, but what I would recommend is to get someone to look at that language and have a discussion about how you can comply with it. Because what sometimes employers will do as well is they will allow you to work for a particular employer. I'm not sure if you are still employed by this employer that you have the non-compete with or non-solicitation, and obviously that would make it more challenging. But a lot of times when there's a termination and somebody has a non-solicit, what we do is we can negotiate with the employer to exempt a certain job from that non-solicit and get a letter saying we're not going to take the position that you're in violation of your non-solicit. And it gives you a lot of peace, because I could say to you, well, your clause isn't enforceable. But if you go work for a new employer and your old employer then sues you and that new employer, by the time you get to the point where you establish whether or not it's enforceable or not, the damage is kind of already done. So I think you need to be careful on the front end. And I would say, give somebody a call and get that language looked at. Another question from Sam. My manager keeps scheduling me during religious holidays I've asked off for, even though others are available. Can this be considered religious discrimination? I mean, again, it could be. I'm not sure what your damages would be in that situation. So, discrimination based on religion means you've suffered an adverse effect in your employment that's related to your religion. So you're requesting time off because of religion, then you're not being accommodated, right? So it's likely a violation of the Human Rights Act. If you're connected to your religion, you're asking for these off and they're scheduling you, it's likely a failure to accommodate. What would be your damages? You're probably not losing any wages, so you're not going to have any wage loss claim. There might be a small amount, small. I mean, in Canada, our amounts for human rights violations aren't huge, maybe $10,000 that could be claimed from human rights for that violation. So, you just mostly have to decide whether or not it's worth it to pursue. And, if you want to discuss that with somebody, again, reach out and contact one of the lawyers at Some Fury to Mark, and we deal with situations like that really often. So we'll be able to help guide you through that. I have a question from Facebook from Jen. I was recently fired from a job after just 1 week due to mistakes caused by lack of proper training. I was told I'd be paid $16 for the entire training period, which involved shadowing, but later learned I should have received at least minimum wage. Since it's a privately owned company and my previous boss was the owner, I'm unsure whether to take action now or wait until I receive my paycheck. I mean, I guess your question is whether to do it now or wait till you're paid. It's always good to make sure you have some money paid from them before start to stir up, a legal claim. So, it might be prudent to just wait until you get paid. I guess also if you're saying that you're not getting paid enough, it's going to be easier to prove once you've actually been paid and you say, look, this is what I got, right? If you try to make the complaint before you actually get paid, you haven't actually been paid yet. So you haven't, there hasn't been a violation of the code yet. And the best way to pursue that would probably be to go on the Employment Standards website and make a complaint under Employment Standards Law, and they'll help you out with that. I have another question from Alex. I accepted a job offer and quit my previous job, but the new employer rescinded the offer before my start date. Do I have any legal recourse? You accepted the offer that was already extended to you, and then they rescinded it after you accepted it. You likely do have some recourse. It's just a question of whether or not it makes sense to pursue it again. So really, if they've offered you a job and you've accepted, that's a binding legal contract, right? It's offer and acceptance, what we learn kind of in our first day of contract law in law school. Valid offer, valid acceptance, it creates a legally binding contract. So if they then have said, no, just kidding, we're not actually going to employ you, you could take action against them for breach of contract, saying, you said I was starting in this job, you offered it to me, I accepted. It would be a breach of contract situation. So you'd have to sort of establish what you would have earned, which probably is in the offer, and how long you would have stayed there. I would, obviously go out, look for other work, and you may be able to recover what you would have earned in the meantime between, them rescinding the offer and you getting a new job. Hopefully that's helpful. Again, reach out to us and we can help you with it going forward. I have another question from YouTube from Eleanor. My employer decided to let me go once I had received approval to return to work for my doctor. I was on short-term disability due to my diabetes. Is this discrimination? Is there anything I can do about this? So employers try this a lot. They say, once you're approved to return, especially if you're returned without restrictions, then they say, oh, well, now we no longer have a duty to accommodate. So if we terminate your employment, it's not discrimination because we're not failing in our duty to accommodate. And that would be different if you're returned to work, if you're supposed to return to work on, say, a gradual return. So say you're supposed to start with only 2 days a week or something, and then they fire you, then, we could say, well, you didn't want to accommodate, and that's why you let this person go. Employers like to try this where, somebody is completely cleared. That means they no longer have a disability. I think that's wrong. You don't just not have diabetes anymore. You still have it. So you still have a protected ground of disability under the Human Rights Act. And if the termination is related to that disability, then it's a violation of human rights. So you could make a complaint to the Human Rights Commission. And again, it likely would be accepted initially. It's going to be on the employer to establish that the reason for the termination didn't have anything to do with the disability. So yeah, it does sound like it likely is discrimination, but obviously there's going to be nuances to it that I would want to hear more about it, as always. So Another follow-up. Oh, this one's from Eleanor too. She's just giving some more details. 6-year employee diagnosed in the last year. The amount of stress at work made it difficult for me to stabilize, so my doctor wanted me to take some time off to get my condition under control. Yeah, fair. You still have that disability, which is a protected ground. So, and they had notice of it. It may be connected. If it is connected to that disability, it's a violation of your human rights. Neil says he was promoted to a new position. Scroll a bit here. New duties, etc. But the training I was promised hasn't happened, and now they're saying I'm not performing well and want to put me on a PIP. Okay, well, if you're on a PIP, even if they put you on one, they have to actually try to help you with what they think is wrong. So, if they're saying that, you're not performing in these areas, what an employer has to do on a PIP, a proper one, and I have seen some that are not proper, but a proper one that's going to help them out at all or is properly, conducted, is they tell you where you need to improve. They tell you how you have to do that. They tell you when you have to do it by, and they offer assistance as to get you there. If you're on this PIP and you're in that meeting, ask them for that. Say, well, I need training to get to this standard. Ask for training. Put that in writing that you're asking for additional training. Because if they are trying to get you to a point where they're going to terminate your employment, and if they are trying to frame it as a performance issue, which would, potentially be, well, we can terminate for cause because he's on this PIP and he's not meeting standards. If you start asking for training and help and they don't provide it, that makes it a lot harder for them to allege cause for dismissal. So that's what I would recommend at this stage. I have another question on Reddit from Victor. I'm in a non-unionized workplace and recently spoke with my coworkers about how we're all underpaid compared to industry standards. We've decided to submit a written proposal signed by all of us requesting a wage increase without any threats or mention of work stoppages. Since I'm the one sending the email, I'm worried if this kind of group action is legally protected or if it could put my job at risk, even though I'm in good standing with the employer. So if you are unionized, it's obviously legally protected because you'll have a collective bargaining agreement, but for a non-unionized employee, requesting a wage increase isn't really an action that could lead to a problem with a reprisal on the part of an employer. If you're asking for things that you're legally entitled to, like if you're asking for, I'm not getting overtime, like where is it? I didn't get paid my vacation pay. You didn't pay me in time under the standards on the code, and you get terminated for that, then that's considered an illegal reprisal under employment standards legislation. Just asking for a raise, it wouldn't necessarily be something that would qualify under employment standards as protected or as something that they couldn't reprise on. That said, if they terminate your employment for asking for a raise, it's not just cause for termination. They might decide they, think it's a personality problem and they don't want to continue the employment relationship, but they'd have to provide a full severance if they did decide to terminate because of that. It would basically be like, oh, this is a personality issue or something like that. So unfortunately, it doesn't qualify as a reprisal in this situation, but it's still, it wouldn't be a just cause termination, so you'd be entitled to severance. Okay, where am I going here? Neil says, well, this is Neil from the being promoted to the new position. And follow-up question, can they just fire me for cause because of this, despite the fact that my performance is due to their lack of training? So that's kind of what I was getting at. So with a PIP, what they're trying to do is they may legitimately be trying to improve your performance, but I think a lot of employers, when they start people on PIPs, what they're trying to do is they're trying to establish that they have cause for termination. So to get there, though, what they have to be doing is they have to tell you exactly what you're doing wrong. They have to tell you exactly what you need to do. They have to give you a timeline in which you need to achieve that. It has to be a reasonable timeline, and they have to assist you to get there. So if they did all of those things, including the assistance part, which would be the training, and you still didn't meet those standards in 3 months or whatever the timeline was, it would probably be just cause for termination. But the problem in your case is that they aren't assisting you. So if they are not assisting you, then it's going to be a struggle for them to allege cause. It strengthens your argument if you're actually asking for that training, right? So if you're actually saying in response to your PIP, I need help, I need training, paper it, put it in an email, in the meeting, write it down. Make sure you're asking for it, because I have had people who've been terminated while they're after being on a PIP. And that has been the argument that we've made. Well, you didn't, employer, you didn't try to assist this person. You didn't give them any help to get to the performance standard that you wanted them at. And then therefore, it's not a just cause termination, right? And eventually, in a lot of those cases, we're able to negotiate and get a good severance package out of the deal, because, they're trying to say it's cause, but they, kind of know it really wasn't cause. They didn't have enough for cause. So that's kind of where I was going before when I was talking about it, that, a PIP is a tool used by employers to get to the point where they can terminate for cause, but it has to be done properly. And one of the main components of it is they have to assist you. So if you're asking for assistance and you're not getting it, then they'd struggle to get to a valid termination for cause. So hopefully that helps answer that question. Another question from YouTube. Our manager has been removing time from our timesheets regularly for the past few months. We've been understaffed and there's been more overtime needed, but he says we need to keep our OT low. Is that legal? He says as long as we aren't working more than 44 hours in a week, we aren't owed overtime pay. Is that right? Well, it definitely doesn't sound above board that he's been removing time from your timesheets. That is, almost fraudulent, right? Like that's not. I can't even think of an actual piece of legislation that would say that that's not allowed. But it's just kind of obvious in a sort of common sense sense that you can't just take your time away. You're supposed to be paid for the hours that you worked. So you've worked these hours and then he's not paying you for it because he's erasing it. That's a violation of the Employment Standards Code. The piece on the 44 hours a week, the way that overtime works is it's if you're working in excess of 8 hours per day or 44 hours a week. So if you work a 10-hour day, but you only work 40 hours that week, you still should get 2 hours of overtime. If you work, okay, I'm going to show my terrible math skills, but if you're only working days less than 8, so if you're working 6 or 7 hours, but you worked every day and your hours in the week are 46, then you get 2 hours of overtime, even if you never worked more than 8 hours a day. So it's one or the other, and it's the standard, it goes to the employee. So it's not like the employer can say, oh, you worked more than 8 hours a day, but you didn't work more than 44 hours, you don't get overtime. That's wrong. It's either 8 hours a day or 44 hours a week is the cap. If you exceed either of those, you should be getting overtime. So hopefully that answers your question, and I think I'm giving you what you're looking for there. It sounds to me like you should be getting overtime. I have another question from Georgia. I'm returning to work in less than 2 weeks after an 18-month maternity leave, and in a meeting with my new manager, I was told they won't keep my previous accommodation of leaving 30 minutes early for childcare. They've also added new expectations for late hours on Thursdays, Fridays, and Saturdays. Something I've never had to do before. I feel like they're using my return as an excuse to renegotiate my role, even offering me a lower position with less bonus. Can they do this? Under the Employment Standards Code, when they return you, they're supposed to return you into the same or comparable position. So if they're changing the terms, material terms, then no, they're not supposed to do that. Also, again, could be something that might be discrimination, might be related to the maternity leave, gender protected ground, family status protected ground under human rights. The leaving early for childcare, there's been cases where, employers have refused to accommodate, and childcare generally qualifies as a, it qualifies as a protected ground under family status under the Human Rights Act. So there's some protection there for if you have to, and there's no other way to manage it. It's a request for accommodation, so you don't necessarily get exactly what you request when you request accommodation. If you're saying I need to leave 30 minutes early, there has to be a conversation with the employer where they go, well, we can't do 30 minutes. How else can we work this, right? So you have to be involved in that, and you can't necessarily just say this is what I need and and you get it. It doesn't have to be perfect accommodation, it has to be reasonable accommodation. But they should be still trying to accommodate that. Again, issues with human rights. If they are changing your role, you could have the ability to take the position that you've been constructively dismissed. Constructive dismissal is where your employer unilaterally, so without your consent, changes material terms of your employment. What that means is basically they fired you. They haven't fired you, but they have fired you, and it entitles you to severance. So, kind of complicated situation. Might be a good idea to reach out to talk to somebody about that to figure out how you can manage it. Biggest advice, general advice is just document everything. Document all these conversations and keep all the emails and everything in case you need to fight it later. I have another question from Nicole. My coworker constantly sends me inappropriate messages, but HR hasn't done anything. What legal steps can I take to protect myself? So if you're saying HR hasn't done anything, I assume you've made a complaint to HR. That's usually the first step that's recommended is, well, first of all, talk to the person and say, stop this. Once you've done that and that doesn't happen, they keep doing it, then, you go to HR, usually escalate it to HR. HR should be stepping in. If they aren't going to do anything, you, again, could have a human rights violation on your hands. So gender is a protected ground under human rights legislation. Gender is usually where we go with sexually inappropriate messages. And if those are being sent, then that's a violation. If the company knows about it because you've complained, hasn't done anything, the company is liable for that employee's actions. So as far as legal steps to protect yourself, document everything. Keep all the messages. Make sure you have them all saved somewhere, screenshots. Take the step of making a formal complaint to HR. And if that doesn't work, come talk to one of us at Samfir Tamarkin. We can help you make a human rights complaint and, assess what other avenues you could potentially follow. If it's creation of a toxic workplace, that could be a constructive dismissal and could entitle you to a full severance. So lots of issues to unpack in that short message from Nicole. Another question from Betty. How much surveillance is an employer allowed to place in the workplace? We've had new cameras installed and everyone is wondering if that's legal. What are they allowed to do with them? So that's kind of a privacy law issue, which isn't really my specialty. I have done a little bit of privacy law, in a prior life kind of thing. But basically with cameras in the workplace, what they're allowed to do is, as long as it's obvious that there's a camera and there's a sign that says, you're being monitored, I think generally it's okay. So there's not like there's an amount, that's, you can only have 3 cameras or you can only have 1 camera. It's basically to the point where they have to tell you that you're being monitored because that goes to your expectation of privacy. If you have an expectation of privacy that is being violated, that's when it's a breach of privacy law. And the way employers get around that expectation of privacy is by making sure it's obvious that you're being recorded, and then you can't have an expectation anymore because they've told you you're being recorded. What are they allowed to do with the videos? They can watch them, and if there's any kind of misconduct going on, they can use that to fire somebody, to lead to a just cause dismissal. I don't know what else they would use them for. A lot of times they say it's for safety, but a lot of times I think they are watching for, misconduct. So, that's kind of all I can think of as far as what are they allowed to do with them. Again, it's a bit of a privacy law issue, which, as I said, isn't really my specialty, but I do know that that cameras are allowed as long as they're not in a place where you'd have a reasonable expectation of privacy, like in a change room or something like that, and that wouldn't be allowed. But if they're in a common area and there's a sign that says you're being monitored, look, here's a camera, kind of cancels out your expectation of privacy. So it looks like that's all the questions we have. So hopefully I answered everybody's questions. And obviously, if I didn't give you enough information, or I said, well, I'd like to know some more details, really consider thinking about, reaching out to our firm at Seffier Markin, and getting somebody to help you with your issue, because a lot of these things are really complicated, and it's helpful to have someone guiding you through the process to make sure that you're going to have your rights respected and you're going to get the compensation you deserve. So thanks a lot for joining in. Really, really great questions today. I'm glad to answer them as usual. I believe we have another employment law Q&A coming up on Thursday, 2 p.m., but that's Eastern time, with Jeremy Herman, and he's an associate way out in our Toronto office. So if you're interested, join in on that. Jeremy's always good for some good content, and I'll see you again next time. Next month sometime I'll be back. Thanks, everyone.